My Lord, thank you. Thank you for taking the short adjournment at that time was most useful. I wish, if I may, to address you about what may sound like a rather daunting 7 points, but I'll briefly set them out and hopefully they will have their own logic. So start by looking at the test for the granting of an adjournment. Then look at H's health presentation. Look at one of the cases, GB, in the bundle and what that says about applying the authorities on adjournment to this jurisdiction. To look at the application that was made to the judge. Look at what the purpose of allowing that application would be. How we would judge the length of any postponement and the length of any period of time, and then at the evidence. And I hope collectively those points will cover the ground. Before that, I don't propose, unless invited, to go back through the points in the skeleton. There may be time at the end and we can return to it. There is perhaps one that is worth briefly covering, which is the question of civil right and obligation. It is, my Lord, of course, a technical, gateway is probably not quite the right word, criterion to be met to bring a claim under the civil limb of Article 6. And I don't put it before you for the pleasure of the technicality, but simply because of the importance of the point where I can't find something directly on the point. Of course, there are related family questions. One thing we would need to do is identify what the right was, which was being claimed. I don't want to divert. I've identified some in my skeleton, but it's not intrinsically, it's not immediately obvious. There are some, of course, which vest in H himself, but he had representative who could take those if appropriate. There are the parental rights embodied in Section 3 of the Children Act, the common law parental rights reflected there. It isn't clear, for the reason I give in my skeleton argument, that they do amount to a civil right or obligation, but we would also need to identify the nature of that civil right or obligation to see the extent to which it ran. And just to take another example, one could raise the question, is it any consent for any procedure? Is it only any longer term removal of the ability to give consent at all? Would it include, for example, consent to a vaccination? Consent to anything for the child could amount to a civil right or obligation. What about the fact that that right diminishes as the child ages and there's a sort of sliding scale? I don't want to go into the complexity.
The parent manifestly has a right to determine whether treatment for a baby should be withdrawn.
Yes.
If we're looking at obvious rights. But this only illustrates the problem if you only focus about looking at these issues through the prism of the convention. The convention exists to underpin, the convention underpins existing common law rights of fairness. And what, yeah.
Well, insofar as one needs the convention, might it be said that Article 8 is a civil right? So the parent, I don't know the answer to that question. It's not a rhetorical question. Could it be said that the parent's Article 8 right is in play? That's certainly being determined in this. If you decide, I mean, it always seems to me that in these sorts of cases, of course one has to bear in mind the technicalities of the law, but one also has to stand back and ask how a reasonable member of the public would view things. And I think any reasonable member of the public, looking at a case like this, would say, of course, the parents' rights are being determined here. Because what could be more profound than the decision whether a child should no longer live? I mean, what could be of more concern to a parent than that?
My Lord, I put it, as I say, because I couldn't find authority on the point, and I thought it wasn't right to not to put it before your lordships if I couldn't find authority on the point. And then, in following the reasoning through, it's that defining the right is more difficult. We have a particular case here, and perhaps one at one end of the spectrum. But if we say that any giving of consent is a civil right or obligation, we perhaps go further than in other cases we would intend to,
Yes.
or find it useful or appropriate when they arose. And that then requires us to start defining what it is, and which is more difficult. And that's, I don't want to take us into the technicalities at all. But that's why I thought it might help if I explained why I raised a point that, my Lord, of course, I understand. One would look at it and think, well, it's a very striking situation. And if I may start by saying that it is a very striking situation, and that, of course, everybody instructing me is absolutely, at all times, motivated by the best interests of H, bringing those to the court for determination. And this is a case where the a second opinion doctor and an expert has commented on the excellent standard of care that's been provided by my client to H, and of course they're committed to that continuing. And I know his parents are in court, and I think it's helpful for them to hear me clearly say that. And this case has been marked by positive relationships, and that is a very positive factor that is also worth saying, and in my position statement for the main hearing, noted as a tribute to them, given the difficult situation that they find themselves. Turning now to the discussion this morning about the nature of an adjournment. It is, of course, a discretionary matter for the trial judge to decide whether to make an adjournment, and the way, in my submission, that is assessed by this court is not a review of that decision, but a decision as to whether it was whether the decision was unfair. And we say that it was not unfair, and defend the substance of that decision and of the proceedings that followed it. And the authority I'll cite for that, it's a new one, which isn't in the bundle, and the reason I use it, it's in the Red Book. And it's not reported, but it's Solanki, Solanki, and Intercity Technology Limited. And the reference, so the citation is 2018 EWCA Civ 101.
So that's not in our bundle of authority.
It's not, because I didn't anticipate that we would be focusing on the domestic question. But it is, if you have a searchable version of the Red Book, it is in...
You mean, when you say the Red Book, you mean the Family Court Practice?
Yes.
Okay, well, I haven't brought my copy up.
No.
My Lord's... Although we could get
it
some.
doesn't say much. The commentary is very brief, 10 lines.
Do you want us to look at the authority?
My Lord, I don't think we need to go to it. It sets out that the test is one of fairness rather than of review, and that is my submission. I know there's been discussion of that in various appellate authorities. For the same reason I don't have them at hand, but that is our submission of the correct approach. Turning then to H's health. I do this again with respect to his parents sitting behind me. Must be difficult to hear, but it's necessary for us to have it in front of us as we decide. We face we turn to analyse the decision that the judge had to make, having that evidence before him. And the evidence is that he suffered a profound hypoxic ischemic brain injury following a cardiac arrest with 30 minutes without spontaneous circulation. And that has left him in a deep coma with no awareness of his surroundings, no signs of consciousness, and now a declining physical presentation. And the evidence given below was that that is not a worsening of the injury, it's the consequences of the injury becoming apparent. And that it includes the following characteristics, which I draw from the third witness statement of Dr. Z. And it is a continuous tonic contraction of his abdominal and thoracic muscles.
We've seen this
You have it.
in the written materials.
Yes.
Obviously, if there are points that you need to remind us of because they're pertinent to your submissions on the appeal, you must. But,
Yes.
but I think you can take much of this as read.
My lord, yes. So the judge was faced with a child with a profound injury whose physical presentation was sadly turning for the worse in across a broad spectrum of ways which would create pain and discomfort for any patient who was aware of them.
And on that point, the position is it's not known whether he feels pain. Is that right? Or was the preponderance of evidence that he did not feel pain but might? Okay.
The evidence was that he couldn't feel pleasure because that requires higher elements of the brain, which one can see have been destroyed and have liquefied, and he's not shown brainstem reactions to pain, but it's impossible to be certain that he doesn't feel pain. He would, for example, or the proposal would be that he received palliative steps if there were to be an extubation, in order to prevent the possibility of pain, which is the common approach in this situation.
I mean, obviously children suffer. Established that children can suffer harm even if they can't feel pain. But in this case, no brainstem evidence of pain, but you can't be sure.
Yes.
Is that the way to look at it?
Yes.
Thank you.
That's right, and that is in my that point is in that section of my skeleton at paragraph 18. My lord, of course, this goes to the question of decisions needing to be taken. There was also at this point no ceiling of care in place, and the lordships will have seen from the notes of the hearing that we began by addressing the judge as to the urgent need for a ceiling of care, and there was a wide, again summarised in my skeleton, a wide range of evidence about the importance of that, including that without it, H was at risk of a traumatic and undignified death, and two examples being given of a pneumothorax requiring steps being taken to, probably with a needle, to remove the air gathering in the chest if that were to happen, or of continuing CPR, and you can see that the judge took steps with Mr and Mrs A to ask them about that during the hearing. So the judge faced a pressing situation of a child critically ill, declining, with at that point no ceiling of care in place, which would require steps to be taken, which the doctors had explained would be traumatic, and the guardian had said it is a factor for the judge, and amongst many others, is traumatic also for the staff on the unit, that they regard those steps as being so contrary to the right way to treat a child in this situation. The contemplation of them is unpleasant for the staff, the risk of having to carry out those steps. So that was the situation that the judge faced in having to make a decision. If I take number 4 now, and then we'll go to number 3. Number 4 is to look at the application. Now the application is in the hearing bundle, and it is at 102. It is, Mr. A says he filed it at 6:05, I think, the evening before the hearing. It isn't, it's written in fluent and flowing English. And Mr. A spoke to the judge at the hearing in English and not through an interpreter. Over on page 107, which is the continuation sheet, at the bottom of the page, one has the actual application that the judge was considering. My lords have the earlier summary and have summarised it back to us, so I won't go through any of that. But this part at the bottom, the last 3 bullet points from 107, if I could ask you to look at those. Sorry, and then over the page, I apologise, the last 2 paragraphs on 108.
I mean, we are working. Right at the bottom.
Yes, thank you. So the application has been put slightly differently in the appeal to this court. There is, in respect of the criminal limb, it is put that representatives were immediately or promptly available. In respect of the civil limb, it is that the state had to provide publicly funded representatives. That's how the permission skeleton is put. It's today the consequences of a postponement haven't been spelt out as to what they would have been, but they were spelt out by the appellants when making the application, and they were, we don't have funding, we have to get funding by crowdfunding. If we are able, conditional, if we can crowdfund, then there is a lawyer who will take our instructions on a paid basis from early September. So the judge was facing a request for an indefinite postponement.
Wait, is it indefinite? Why couldn't a judge say, I will adjourn, perhaps not even accept the 3 weeks suggested? May say, I'll adjourn for 1 week or 2 weeks. Why couldn't the judge say, well, I'm really sorry, if by then you still haven't been able to obtain funding, then I'm afraid we're going to have to go ahead because the urgency of this case is such. The difficulty, it may be thought, is that that's not the approach the judge took at all. The only reasons we have are the ones he set out in his judgment at paragraph 43. And he doesn't set out any of that thinking.
Well, if the judge had adjourned for a different period of time, he would have faced the objection at the time and then a week later that he hadn't provided people with the opportunity to do any of the things they had asked for.
Perhaps so. But all I'm saying is I don't read the application as being one for an indefinite adjournment. But even if it was to be read like that, I don't myself see why the judge couldn't have said, look, you've said minimum 3 weeks. I'm prepared to give you 3 weeks and not a day longer. And if by then you haven't got the funding, I'm sorry, we're going to have to proceed.
What the judge didn't have, my lord, was any way of making a decision that legal representation could be available over a reasonable time period. And one of my points was, what is a reasonable time period? Not, I'll go to that. But had he been adjourning on the basis that you don't have legal representation and that's what is the motivating factor, nothing was put before him that would allow him to see the remedy of that.
Well, this problem arises quite frequently, in family cases. Representation has to be obtained very quickly, and there's a pro bono, much stronger pro bono service now available, now called Advocate, isn't it?
Yes.
And many young barristers are signed up to that scheme. Wouldn't it have been possible for the judge to have instituted an inquiry, perhaps through the court office? This happens on appeals, The Civil Appeals Office makes inquiries to see whether a pro bono advocate can be found. Why could the judge not have done that? And why would it have to be necessarily 3 weeks?
Well, two such attempts had been made. So
But in August.
So it would be simply a question of making a further, inevitably speculative request that perhaps someone will be available at the first week of September. It's a limited basis to say, in my submission, that what the judge did was unfair. He had to balance up a range of factors, and one of them was that people were appearing who say in their application that they have been, just checking I'm right about this, but I believe they say they have been helped to approach advocate.
Well, if we look at the last page, last sentence of 108, the period of 3 weeks is at the end of a sentence in which they talk of instructing an independent expert. Well, it would have been perfectly open to the judge, wouldn't it, to say we don't need another expert, because the parents were involved and represented in the instruction of Dr. B, and another expert's not required. So the 3 weeks period, which is predicated upon the need for another expert, is excessive. Let's look at whether we could do it next week.
Well, except that we know from the application as put that they couldn't, because they say they don't have funding. So it might have been that an alternative.
Yeah, but I'm talking about now about a pro bono.
Yeah.
All this could have been explored by the judge, couldn't it? He could have explored further whether pro bono representation would be possible next week.
But
or
he
in 10
did
days.
have a contact. It is here. It does say here that they've been to advocate. So he did have a context where advocate had just been asked, and so we would really be saying that the fact that it was August means that we think someone could be available in September.
Well, why is that? The advocates, I understand it, were asked specifically about August the 25th and 26th.
They were asked for this. As my understanding,
Why
I
would
didn't ask them.
Why would it be remotely surprising, and it certainly wouldn't come as a surprise to the judge to know that there were difficulties finding someone to act pro bono in August? Whereas that position might well be very different as of the 30th of August, just after the bank holiday.
It might. I mean, but that's all we. By submission, that's all we can say. It might be different.
Well, we can certainly say it's going to be easier to find an advocate after the end of the school holiday.
I mean, there are people who never find. There are cases that don't get matched up with people through advocate. So it may be that no one will be available at all. But I'm not suggesting, of course, that any one factor is the end of the debate, and I'm obviously not suggesting that that avoiding the double negative. Clearly, people are more often away in August than when the schools have gone back. That's obviously the case. But the situation the judge had was a pressing need, and someone who had lost legal aid and attempted to find pro bono representation, been helped to find pro bono representation, and would only be able to fund representation through public fundraising. A difficult situation.
But he doesn't seem to have investigated any of this or considered it. Did he? Can you point in the judgment or in the
Well,
hearing where he considered whether there could be an adjournment and how long for, and what prospects there were of getting representation given the history of their attempts? You didn't consider any of that.
Well, he considered whether the application as made was one which should be allowed in the context of the evidence before him, and
So the answer to my question is no, is that right?
and came up with pithily expressed reasons why he should follow the pressing needs of the child. But the question before us in my submission is whether that was fair, and we say that it was. And I'll keep moving through my factors for why.
Right, you dealt with your topic 4,
Yes,
which is the nature
and I
of
jumped
the
through.
application. You're now on topic 3.
Yeah, I jumped through. Because having looked at that, having looked at the application, if we now go to in the bundle of authorities 486.
We now have a hard copy.
I think, in fact, it's only
I say it's the royal we. There is one hard copy. Well, have you got this electronically?
Yeah, I have it. Page 486.
Yes.
Yep. Which paragraph?
So it's a care case, and I was just going to take you to paragraph 24, which says the second primary ground of appeal is the judge was plainly wrong, not granting an adjournment, so the mother's position could be better protected by legal representation in the event she might have further children. And then the tests are set out from 44 on 490. And the judge, it's Lord Justice McFarlane, I believe, adopts and approves re B and re T at paragraph 45. And in that passage says that in non-adversarial proceedings, the judge always holds an inquisitorial responsibility. It's important to avoid delay. One has to bear heavily in mind the rights of the child and the mother has had extensive legal advice. And one can apply all of those points over to this case and reach, we say, the conclusion that it was fair to proceed with the hearing. One can see from the notes that the judge did take an inquisitorial role, asked a number of questions of the witnesses, both Dr. Z and the independent expert, Dr. Brierley. And one can also see that the basis on which the judge proceeded reflected a background where the parents had had extensive assistance and input. And I would disagree with the gloss that my learned friend for the appellant is putting on that by saying that not much was happening in August. It's not clear to me what the evidential basis for that is, but we can see from page 21 of the bundle the instructions to Dr. Brierley, and we can see at page 23.
Before we leave this authority,
Yeah.
If you read on, Lord Justice McFarlane cites a decision of Lord Justice Thorpe's called Re B and T, but he then cites another, or alludes to another decision of Lord Justice Thorpe's, paragraph 47, which they didn't have because it had only just been handed down. in which the court had reached the opposite conclusion. Such limited information as was available to Lord Justice McFarlane and the court in this case is summarised in paragraph 48. And that leads Lord Justice McFarlane to observe, and they include, by the way, a number of factors such as the vulnerability of father and other matters. And at paragraph 49, Lord Justice McFarlane says, "It seems to me that issues such as the one raised in the present case will of necessity be fact specific."
Yes, and one can see in 48 that also in the Riel case, the case wasn't urgent, which was another reason that is suggested here led to the decision to grant an adjournment about 6 lines up from the bottom towards the middle. So, but indeed, with any, one can try to identify criteria, but with any appeal of a discretion, one is going to be looking for something that is that is fact specific.
Would you accept that one of the factors to be taken into account in deciding whether to adjourn or refuse will be the reason why somebody is now without legal representation? So there are cases, for example, when I was sitting in the Crown Court, not infrequently, the defendant would sack his legal team. That's one kind of reason. There may be other reasons. My lord mentioned earlier, it may be that somebody has fallen ill at the last minute. Would you accept that's a relevant factor to be taken into account?
But my hesitation, my lord, is because what one can see that one could come up with a list of 20 factors to be taken into account and end up leaving judges in impossible positions. That there'll always be, and then they end up needing a checklist. And so we get judgment by checklist. And perhaps that is why we have ended up with the position that the test is fairness and fairness in the proceedings, which also allows your lordships to make, to an extent, limited by being an appellate court, but to make a substantive assessment of what was fair, rather than to review the decision making as to what was fair. So that my lord, is my hesitation for that.
I mean, there are a number of factors here which point in favour of the adjournment. A number of factors. This was an unexpected development in the sense that the parents had expected to be represented, had been represented all the way through, had not therefore got involved in the preparation in the way that a litigant in person would do if they'd been in person all the way through. It was a complex case with a lot of material, technical material. It was a very serious matter, and it was almost at the last minute that the problem arose, at a point where they couldn't find alternative representation that week, despite everybody's efforts, including those who instruct you.
Yes.
So all those are strong arguments in favour of an adjournment.
And my lord, yes.
Where do we see the judge weighing those in the balance?
Well, they were dealt with by a set of steps which made the proceedings fair overall, and they were. You can see actually right from the beginning, the judge pulls me up, and I was equivocating and hesitating about saying straightforwardly what the medical evidence was, and you can see the judge stops me and says, "Make it understandable." So I'm trying to be kind, and he says, "Yes, get on with it."
That's the later stage. My question is, where do we see the judge weighing in the balance when deciding whether to adjourn those multiple factors that I have mentioned to you, which pointed towards an adjournment?
Well, there are two sources of the judge's thinking. There is the note taken of what was said in court, which begins, I think, a couple of lines before you were taken to when you were looking at it earlier by Mr Quintavalle. I don't think we need to go back to it, but it says, talks about what other counsel have said, talks about the public interest and the interests of H. And then there is the judgment itself explaining the people and the factors set out there about.
Yeah, that's my point. He doesn't, and none of the points I've put to you are expressly taken, weighed in the balance by the judge.
Well, that again, my lord, goes back to the point earlier that in my submission the question is fairness, and that this was a fair, a carefully conducted and fair hearing.
So, are you conceding that the judge? You're conceding that there's no evidence that the judge took into account when deciding not to adjourn those matters I've put to you?
Well, we have.
Sorry, let me finish the point.
Yeah.
Your defence, as it were, is that having taken the decision, he ensured the hearing was conducted fairly.
And
you have to look at the whole hearing.
One looks at the whole of the proceedings. It's certainly in the Article 6 authorities, which are cited in the skeleton before you. You look at the conduct of the whole proceedings and see if they were fair, and they were fair. The evidence we have is the note of what was said and the reasons which were given, and one can come, one could come up with a checklist of 20 factors as to what you could take into account in making these decisions. And we say that the judge had a case before him with pressing circumstances which he identified, explaining the decision that he made. But in any event, the outcome was a fair one. The decision was fair and the proceedings were fair.
Right, so that you were showing us GB, that was your topic 3.
Yes, sorry, indeed. And
I've got an eye on the clock, although I'm not going to impose a guillotine at 2:25.
No. Yes. So we've looked at the application. The other thing is simply to identify the purpose of an adjournment.
Which topic is this?
5.
Thank you.
You have my submissions in the skeleton argument about the difficulty with legal aid, and that seems to me is an insuperable difficulty for the claim as it is put under Article 6, which is the reason why the appellants lost legal aid is means. And it's clear in criminal as well as in civil proceedings that a means test can be imposed. I have copied the part of the email in my skeleton argument from Erwin Mitchell to my instructing solicitors, which states why public funding has, it's not clear to me if it was lost or not granted or granted provisionally, but why they don't continue to have public funding. And it is based on means. And nothing else appears from that email. And it's clear that the state is allowed to have a means test in both its civil and its criminal systems. And both in Good and Nafisine, the judicial review of the guidance on special case funding from this court, from the Court of Appeal, and in the cost judgment in Rakib, that has been approved, I mean directly approved as a matter of the ratio of Good and Nafisine, that one can have a means test in civil legal aid.
I'm looking at the terms of round 1 in this appeal.
Yeah.
Which is the only ground now pursued, page 164 of the call bundle. By failing to adjourn the proceedings to allow the proposed appellants to be legally represented, the court breached the proposed appellants' fair trial rights, protected by Article 6 ECHR. There's nothing there about the failure to give legal aid.
If we look at how it's then put in the skeleton,
oh, yes,
in the skeleton argument.
That I understand.
Yes.
But it does seem, speaking for myself at least, it does seem to me that read fairly, the only ground of appeal before this court does squarely raise the question of whether the failure to adjourn the proceedings to allow the proposed appellants to be legally represented breached the appellant's fair trial rights. Now, it is true that it goes on to mention that those rights are protected by Article 6. That's true, they are. I'm not sure the substance of the complaint is confined to Article 6, because actually one could have stopped after the word rights, and it would still have been, whether sound or not, that would still have been a perfectly comprehensible ground of appeal. The essence of the complaint appears to be about the failure to adjourn. That's what I'm saying. It's not about failure to give legal aid.
Well, two points. That, in my submission, is a composite sentence in which it's the objection is to the rights protected by Article 6. But I don't need to debate the terminology. The way in which it's to be made out, it cites two issues about the granting of about representation. The first is representation was available. We've seen that just appears to be wrong. And the second is that the state had to provide representation. And so my reply to the ground is, what's the purpose of an adjournment? Now, one can see in a way it's made out in the permission skeleton argument. It's so the state can grant legal aid. But the state has refused you legal aid for a reason it's allowed to refuse you legal aid, and you don't have funding. So
but you yourself showed us a moment ago the original application, and that suggested that one possibility was that the parents would obtain funding by crowdfunding. So that's nothing to do with the state funding it. I mean, I may be wrong, but certainly as I have read Ground 1, it seems to me that the thrust of its complaint is that the failure to adjourn was unfair.
And my reply in this point 5 is, in analysing that, one has to consider what the purpose of allowing an adjournment would be. And it would be to allow representation. And we have had two ways in which that might have happened, both of which one would expect to find extremely poor reception from a judge if making an application to adjourn on that basis. To say, I wish to adjourn because I wish to crowdfund in order to provide legal representation in a case which is pressingly urgent is an unattractive application. And to say I wish to adjourn because I have been refused legal aid on the means test is also an unattractive application, because why do that? Unless you're going to judicially review the legal aid.
I'm sorry, Mr. Lawson. It may be that I'm unusual, but if I know I'm not the first instance judge, and I remind myself that I must look at this through the appellate court's jurisdiction. I appreciate that. But if I had been the first instance judge, I would not regard it as an unattractive suggestion in principle. If a party said to me, leave aside the particular sensitive context, this is it, but in a civil case, if a party said to me, look, I had legal representation until recently, I don't have it now, can I please have 3 weeks to see if I can secure alternative funding, perhaps by getting a loan or by donations? I wouldn't regard that as being unattractive in principle. I might then, having weighed that in the balance, I might say, well, actually, I'm sorry, we have to press on today because of these other factors, and I do the balancing exercise. But as my Lord has said, what, at the moment at least, we cannot see in paragraph 43 of the judgment is that balancing exercise being conducted.
Shall I move on? I'm going to come to fairness at the end.
Can I just come back to your fifth point? Like you, originally, I'm sure it was my reading, I thought this was going to be a challenge to the legal aid, Lasbury, the legal aid provisions, but it isn't. And it's made clear that it isn't in Mr. Quinavale's paragraph 22 of his reply, where he says that in a situation where legal representation is required under Article 6, and the state, through the legal aid agency, was not willing to grant legal aid, it fell on the courts as emanations of the state to give effect to the state's obligation by granting a short adjournment to enable legal representation to be arranged. So that's absolutely clear. That is what, as my Lord says, that is what this case is about. Contrary to what I agree, it looked like at first.
Yes, my Lord. And so on this particular fifth point, my reply to that is that a number of other factors, we've looked at the urgency and so on, but on the fact there's a problem of purpose for that, which is that the options for providing representation which were put forward were in my submission very difficult ones. They were ones that have been tried and had failed, might succeed in the future, and of course I accept that September is different. Of course I accept that September is different from August, but it's a speculative point as to not every case gets a representative, and which required conditions not in the control of the person seeking the adjournment, i.e. other people will provide us with money, which hadn't yet started to happen. It's not, well, we've got some coming in. We could start to do that.
Right, that's your
Yes, that's my
fifth topic.
Then we also need to decide how to judge a period of time. In Re-M, which was a case of this court about declaration of death, the judgment ends by expressing concern that the case has taken 4 months to reach the Court of Appeal. And this case has now had 85 days, so it's coming up to 3 months. It was over 70 by the time of the, whatever, 70 by the time of the hearing. There was evidence before the court in Dr. Zed's third statement that the average length of stay for a child under 1 is 4 days. And there was evidence about the pressing risks that gave to this child of a poor outcome. And the fact is that not making a decision is itself a decision. It is a decision to continue treatment for a period of time, which I won't go back to any of the points about how long that period of time might be, for a further period of time, exposing the child to all of that unjustified treatment. We need to see that the evidence from Dr. Brierley, the independent expert, was that the treatment didn't have an ethical basis because it was futile. We'll come to the evidence in a moment. So, how do we judge the length of time? Even 7 days is to extend the time of H in the hospital by 10%, and to double the length of time of a normal 1-year-old, of the average 1-year-old child, of 4 days in Dr. Zed's witness statement. So even a week is a...
4 days has been the average for what exactly, did you say?
A child under 1, let me get...
Average for
right.
what for a child under 1?
Time in the intensive care unit is page...
In PICU?
Yes, C77. Okay. Fewer than 20% stay for more than a week. And
in PICU, got it.
Yes.
Okay.
So it is any time is significant, and one can quickly, by small periods of time, and this is one of the things the Court of Appeal said in Re-M, quite small periods of time, an attempt to mediate here, an extra meeting there, quickly add up to a number of months. And then 7, the evidence. May I very briefly, before going to that, make some points that should be made about brainstem testing. My Lords responded as Mr Quintavarli made those points, but I think there are some brief points that I ought to make. This situation isn't unique. The expert, Dr. Brierley, it's F36 of the first instance bundle, includes a piece of literature of another case in which someone started, I think from memory in that case, 15 hours. Started breathing 15 hours after a brainstem test.
Had there been several brainstem tests, as there had in this case?
My lord, I'm sorry, I don't know. I don't recollect. If in that case, whether there have been several, but someone breathing again isn't unique, and one can see that Dr. Briley advises that in most cases where people breathe again, it's due to error in the testing,
Yes.
which implies that there's been other cases, albeit with a different background. And my lord raised with Mr. Quintavalli the use of words such as people insisting on something, and
I did, yes.
the trusts would have made the same points. Does now make the same point. It isn't about somebody insisting on something. There were people, doctors from other trusts, who carried out second opinion tests, including one at professorial level, and then both another second opinion doctor and an independent expert have both validated the tests as having been carried out properly by all of the people who carried them out. Now,
For my part, I'm not sure that the arguments in favour of an adjournment were added to by the admittedly extremely unusual history about the brainstem testing. Just as, for my part, I don't think they're added to by the criminal investigation in the background.
no, my lord, that was one of the ways in which this case was presented was exactly that. To say that the background of the brainstem testing is relevant to clinical practice, and the judge heard evidence that it's being dealt with at national and international level to review. Probably it's going to relate to babies with open fontanelles, and the possibility that gives of relief of pressure.
So they wouldn't be used in children under the age of 18 months or something like that.
So there'll be, I mean, whether that's the date, but there could be some change being made like that. But the situation is under review, and
Now, Mr. Lawson, I said I would not impose a guilty
Yes.
plea, but how much longer are you going to be?
I'm on my 7th point. So
Yes.
before I went to it, I just wanted to cover the point
Are you just
about.
going to tell us, identify pieces of the evidence?
Yes.
Right.
Do you need to read it out? You probably
No.
don't.
All right.
No, I don't. We have seen that Dr. Briley was given specific instructions drafted by lawyers working for the appellants and the Guardian. And they raised a number of questions: movement, heart rate, variation in the size of the pupils, and growth, which the appellants wished to raise. And Dr. Briley's report answers each of them, explains why the issues raised by the appellants arise, identifies whether they do arise, and gives an opinion of it. And actually, the paragraph that Mr. Quintavalli took us to from Latinovic in Croatia says what you have to do is allow the expert to examine the evidence. And that's precisely what did happen in this case, that there was so far as we're aware, a state-funded expert who examined the evidence on instruction from
Putting questions from the parties,
from the appellants,
including the appellants.
and then came and gave evidence. And one can see from the notes was questioned by the judge and leading counsel for H about those particular factors. And the judge, I can take it, but I am mindful of the time. And the judge and Ms. Watson, Queen's Counsel, went through particular factors raised by the parents, and the judge comments that Ms. Watson had sought to bring out points that could have been raised. And if we then have to recognise that evidence from a wide range of sources, second opinion evidence from 2 different trusts, 3 doctors from this trust and an independent expert, all came to the same conclusion. Now, we all know that one can say, well, a commonly reached view, of course one can say that. They then attended court and gave evidence about that, explaining the factors that led them to rely on that, having answered the points raised by the appellants. there wasn't anything on which an advocate could build a case. And when one looks at the points raised in Mr Quintavale's skeleton argument in reply, they go no further. Some of them are irrelevant but medically wrong. One was raised in the preliminary hearing in the dance litigation about the impact of the brainstem tests, and and the judge, Justice Arbuthnot,
Yes.
said that there isn't a medical basis. You haven't put a medical basis before us for saying that the test would do any harm. So we haven't yet had put forward a question that could be asked, and considerable steps were taken to ensure that the proceedings were fair.
So you've drawn attention to Dr. B's evidence, part of which, all evidence, written and oral evidence, included express consideration of questions which had been raised on behalf of the parents.
Yes, exactly. The parents were present, asked questions of a witness, were treated as being parties.
Just Dr. L, I think. Was it Dr. L?
It was Dr. L. The people with me say that they were invited to ask from other witnesses. We don't have the transcript. We only have the notes, and you have the notes as well as I have them. You can see they were asked in respect of the guardian, so the other witness would be Dr. Brierley. And they spoke, giving to the judge, giving evidence about what they thought. They weren't questioned, so they didn't need the protection of a lawyer for that purpose. And you can see from the position statement that we had removed any reference to the criminal matters from.
So when they addressed the court, it wasn't sworn. So you're saying it was a sort of mixture of evidence and submissions they were putting their case. Is that what you're saying?
Well, it's referred to in the notes as evidence,
Yes.
and the words are used. I think the judge says you can give evidence. So my submission is that they were giving evidence. They were giving evidence about their opinion and their experiences. So my submission is that was evidence, yes. And that they were protected by the way the case was presented, that there was nothing there that would have done them any harm. And they didn't need a lawyer for that purpose. They had intervention both from a representative of the guardian, and I've put the authority in my skeleton argument for the striking role of the guardian in family court proceedings and the importance of the guardian, and from a judge who one can see asked questions of the witnesses. I'll just have one moment. There's one other thing. May I turn my back just for a moment? Thank you. Thank you, my lord. The only other matter was just in terms, again, of help to the appellants during August. They did, during that month, serve witness evidence. We clearly don't have all of their emails with their solicitors because there's a reference in their first statement to an email of the 17th of August about losing representation that we don't have, and there must have been lots of emails about means that we don't have. So we don't have the full set of emails with the solicitors, but we do know that witness evidence was served, and we do know that Dr. Brierley was instructed and that follow-up questions were asked of Dr. M, one of the second opinion doctors. So steps were taken to identify and put their case during that month, And it's our submission that Mr Quintavares, I know it's no doubt the flourish of an advocate, but to say that the appellants were spectators in the hearing is, in my submission, unfair on the judge on any basis, and that the judge from the start can be seen to have conducted the proceedings in a way that was accessible to the parents, can be seen to have called on them to ask questions and give evidence.
Why didn't he list them as appearing?
Well, he did, however, above that, list them as litigants in person. So he recognised their status as litigants, but didn't list them as advocates. But he did expressly state that they were litigants.
And you think that's a good enough explanation?
Well, my lord, I think it indicates the important factor, which is the judge's understanding of their role in the proceedings, and we can see that reflected in the way he conducted the proceedings, that they were involved in the ways I've said by taking part in the proceedings, which from the beginning were dealt with in a way which was to be accessible to them, and in that sense revolve around them. And you can see in the way he talks to Dr. Brierley and then refers in the judgment to Dr. Brierley's ability to express factors. I was actually going to say that the way Dr. Brierley's evidence is dealt with by the judge in the judgment, we would say is a model of the way to deal with these things, and shows a careful awareness of the issues raised by the parents and goes through them and goes through them, showing that he's considering the parents' case. The factors identified by the parents is specifically addressed by the judge. My lord, thank you. Thank you.
Mr. Anderson. Again, I'm not going to impose a guillotine on you, but we'll be expecting you to be around 30 minutes.
Yes, thank you, my lords, and perhaps unsurprisingly, much of what I might otherwise have said has been addressed by Mr. Lawson in the course of his submissions and exchanges with the court, so I hope I'll be able to stick to that. My lords, first of all, in my submission, it is right in principle that the court should start by viewing this appeal through the lens of common law fairness. And in my submission, in reality, Article 6 would add nothing material to the requirements of common law fairness. So I want, first of all, just to make a few brief submissions in relation to the issues arising in connection with Article 6, and then move on to principles relevant to common law fairness, and then get into the meat of the particular facts. So first of all, in relation to the scope of Article 6, in my submission it's clear that this matter did not fall within the criminal limb of Article 6. I accept that the concepts of defending a criminal charge or determining a criminal charge have an autonomous meaning for the purposes of the ECHR. And I accept that there are circumstances in which, where individuals are arrested and interviewed in connection with a potential offence, that may suffice for a charge for certain purposes in the context of Article 6 of the ECHR. But none of the cases relied upon by the appellants in these proceedings are remotely analogous to these proceedings, for reasons I've set out in paragraph 28 of my unredacted skeleton argument. And as you weren't taken to those cases in oral argument, I don't propose to say anything more about them, but rest on written submission.
Paragraph, say again.
Paragraph 28 of my unredacted skeleton argument.
Yes, thank you.
There was, in oral argument, a reference to Lecomte and Belgium, but in common with the other cases relied on, that was squarely concerned with steps taken in relation to the investigation of culpability, in that case in the context of revocation of medical licenses, whereas the present proceedings were nothing to do with an investigation of culpability or a preliminary step in relation to any criminal investigation. They were best interests proceedings in which the parents' standing, as it were, was in their role as parents, and therefore people with a right to be involved in decision-making affecting their child. But in my submission, there's no authority that would support assimilating those proceedings to the defence or determination of a criminal charge. And it would be wrong in principle to do so, where that would potentially distort proceedings away from their proper focus on the best interests analysis. My Lords, in relation to the civil limb of Article 6, the Guardian submits that it probably is engaged in a case such as the present, by analogy with the authorities in relation to contact and custody, and by reference, in a sense, to the common sense question that my Lord Justice Singh posed in the course of the hearing. I'd submit the court doesn't necessarily need to determine, though, that point, because for reasons I'll go on to submit, Article 6 doesn't add anything to the common law in this case. But I should perhaps just briefly note in relation to the suggestion that the fact that Article 8 rights are in play would mean that Article 6 is then in play. And in my submission, that would be contrary to authority. In particular, the case of Maui and France, which you don't have as an authority separately in the authorities bundle, but is quoted in Godana Vicieni, which is at tab 19 of the authorities, page 517, paragraph 60.
So page?
Page 517, paragraph 60.
Thank you.
Effectively making the point that Article 6 didn't apply in the context of deportation proceedings, notwithstanding that there was a significant impact on family rights.
Yes.
It's also possible that the procedural dimension of Article 8 could separately be in play, even if Article 6 weren't. But in any event, in my submission, none of that would lead to conclusions that require a higher or different degree of fairness than the common law would require. And in relation to that, the relevant principles are summarised in the case of PC and S, which appears at tab 14 of the authorities bundle, pages 362 to 363, and it's paragraphs 88 to 90, and I've extracted the relevant propositions, I think, at paragraph 30 of the unredacted skeleton argument.
Intellectually, as a matter of principle, there are circumstances in which Article 6 can add something to the common law,
yes.
and cases which have concerned the failure to provide legal aid, when they've reached Strasbourg, have sometimes demonstrated that. So where the domestic legal system, when considered in the round, has been found to be incompatible with Article 6 because no legal aid was available or was provided. An area against Ireland was the origin of that intellectually. So there can be such cases, but I think, having read the written submissions and having heard the oral submissions, what now appears to be clear in this appeal is that, although this may not have been entirely clear at the outset, it has now become clear that this case is not really about the failure to provide legal aid.
Yes.
Which is actually a decision by somebody else. There wasn't a decision of this judge.
Yes.
What this case is about, as I understand it, is the decision by this judge not to adjourn in circumstances which included the fact that legal aid had not been made available. And so what the question arises, what was he then supposed to do?
Yes.
And did fairness, either at common law or under Article 6, require him to adjourn in the circumstances in which he found himself?
My lord, yes. I mean, the Guardian agrees with that. I mean, there is no challenge to the refusal of legal aid in this case. It's not clear whether there was any appeal or any appeal mechanism. But in any event, this court isn't faced with a challenge to a refusal of legal aid. It is squarely faced with an argument that the refusal to adjourn was unfair. And the Guardian would agree that that's the basis of which it falls to be analysed. My point is simply that in that context, in my submission, the factors that you would look at, or the Strasbourg court would say that you should look at in terms of considering whether or not an adjournment was necessary in order to ensure fairness, are essentially the same factors as a judge would be looking at if they were asking that question at common law. And so the Article 6 analysis is unlikely to add anything on top of it.
Where in particular in PCNS does it say that?
It doesn't say that in PCS and S and UK, my lord, but the factors that the court identifies as being important, and I've set these out in the second bullet point of paragraph
Yes.
30 of the skeleton, would include the complexity of the procedure, the necessity to address complicated points of law or established facts involving expert evidence and examination of witnesses, the fact that the subject matter entails an emotional involvement incompatible with the degree of objectivity
So
required.
these are the factors which, as well as being considered, these are factors which the court should have considered when considering the application to adjourn.
These are all matters that would be relevant to
Right.
considering an application. And it goes on to note as well, of course, that the court would also have regard to the rights of others as well. And that's set out at paragraph 90 and PC and S. My lords, if I could also invite you, in common with Mr Lawson, carefully to consider paragraph 50 of Litincic and Croatia, which he took you to tab 21, page 702, paragraph 50, where the court is talking specifically about requirements in relation to expert evidence. I'm just going to bring that up, if I may. And what the court said at paragraph 50, in the context of expert evidence, the rules on the admissibility thereof does not deprive the party in question of the opportunity of challenging it effectively. In certain circumstances, the refusal to allow further or an alternative expert examination of material evidence may be regarded as a breach of Article 6, paragraph 1. In particular, where an expert has been appointed by a court, parties must in all instances be able to attend the interviews held by him or her, or to be shown the documents he or she has taken into account. What is essential is that the party should be able to participate properly in the proceedings before the inverted commas tribunal. And then at paragraph 51, it notes that doesn't mean that the expert themselves needs to fulfill those requirements. The opinion of an expert appointed by the competent court to address issues is likely to carry significant weight. And it then goes on to say that the lack of neutrality on the part of a court-appointed expert may in certain circumstances give rise to a breach of the principle of equality of arms inherent in the concept of a fair trial. What the court doesn't say, though, and I think this is important in the present context, is that there will necessarily need to be an opportunity for legal representatives to cross-examine a court-appointed expert in order to ensure procedural fairness. And of course, there are many cases in which the court receives expert evidence on the basis of considering written reports alone, or written reports together with answers to questions that have been posed in writing, or limits the extent to which expert evidence may be cross-examined. The common law and Article 6 are likely to look at the same factors is, in my submission, reflected in the decision of this court in GB Children, which appears at tab 18, the authorities bundle, page 490, paragraphs 45 to 46, in which Lord Justice McFarlane quotes from the decisions of Lord Justice Thorpe and Lord Justice Buxton in the B&T case.
49, did you say?
It's 490, page 490, paragraphs 45 to 46. Now, I think it says, I think, that it's all from Lord Justice Thorpe, but in fact, I think the internal quotation of paragraphs 21 and 22 comes from the judgment of Lord Justice Buxton in B&T. And those are the passages in B&T which I would otherwise take you to, which appear separately in the bundle.
Would you accept the proposition at paragraph 49 that issues such as one raised in the present case will of necessity be fact specific?
My lord, yes. These are looking at factors which will have greater or lesser salience depending on the particular circumstances of a particular case. But the points I do take out of it are that you need to look at the whole proceedings. You don't look at particular elements of them in isolation. You can look at legal advice and guidance before the hearing as well as at the hearing. You can't look at fairness in the procedural sense as being necessarily paramount to fairness to the interests of the child in terms of the determination of the relevant issue. That, of course, is in the context of care proceedings, but in my submission it's analogous to the sort of best interests decision-making in the present context. And you have to look to whether there was an opportunity for the parties, for the relevant party to put their case. And Lord Justice McFarlane considers the PC&S case and effectively considers that it's in harmony with what's said in B&T. So, my lord, I had wanted to submit in relation to the relevant principles. And when we turn to their application, the facts of the present case, first of all, this is plainly a case concerning a very serious issue and a matter of extreme importance to the appellants. Secondly, it's also plainly the sort of issue in relation to which, generally, there will be a lot of emotion. And that's not just true generally, it's also reflected in the present case. One looks at the notes of Ms. Bogle and Ms. Watson, Queen's Counsel, and in the evidence from the appellants themselves. Third, the fact that the appellants were without representation at the final hearing was in no sense their fault, and it appears from the background will have come as something of a surprise to them. So those are relevant matters to take into account in considering whether or not the refusal of the adjournment is fair. There are other factors, and those factors, I think it probably goes without saying, are all factors that would potentially be in favour of granting an adjournment.
There are others too, perhaps?
But there are other factors as well.
Other factors, as it were, in favour of the adjournment?
Let
me suggest some to you. The late hour, the late stage in the proceedings at which they became unrepresented, having been represented throughout.
Yes.
Meaning that they weren't expecting to be unrepresented. It's sort of covered to some extent by your last point. So late hour, you'd agree, and unexpected. So it's not as if they'd been preparing all the way through for 6 weeks that we're going to have to do this. They had only a few days.
It plainly came as a surprise to them from the
and the complexity of the case. and the volume of the evidence?
The evidence is certainly technical in nature, although I think in fairness to both the clinicians and the judges, they have also sought to express their conclusions in comprehensible terms as far as they can. But yes, the evidence is of a technical nature.
And complex. And voluminous too. The one includes the medical records.
Yes.
Extensive.
So there are plainly factors that would stand in favour of the grant of an adjournment. But there are also factors that were standing against the grant of an adjournment. First of all, whilst the fact that the appellants had been represented at an earlier stage is relevant in favour in one sense, in that it goes to the fact they would have been expecting to be represented, may have been surprised not to be. On the other hand, they had had the benefit of legal advice and assistance at the direction stages, which included, of course, setting the timetable and directions for obtaining further evidence, identifying and instructing an independent expert, and you can see that there was assistance in relation to the drafting of the instructions from their solicitors, and also assistance in terms of preparing the 2 witness statements which were filed in the proceedings. So that's an important factor. Secondly, picking up on Litincic and a point Mr Lawson made, the appellants had put questions and concerns to the medical practitioners in the context of that evidence gathering exercise. So Mr Lawson referred you to Dr Brierley, and in particular he addresses their concerns at F25, where he addresses various signs which the appellants took to be evidence that A was potentially recovering. But you will also see that there is, from Dr M, who provided a second neurology opinion. The second opinion itself appears at F10, and then at F17 there is a separate document from Dr M in which he responds to parental questions. Now I should say, my lords, it isn't clear to me from the materials exactly how those questions came to be put, whether it was in the course of discussion or in writing, but they had had an opportunity, it seems, to raise questions or concerns with him. And that's important because the key point that Mr Quintavalle has referred to in terms of the potential disagreement in relation to the medical evidence, which from the clinical perspective is all speaking with one voice, is the point about the appellants having seen various signs and indications which they take to indicate that his condition may be different than what's described. And those concerns, we've had the opportunity to raise those concerns with the relevant second opinion doctor, and also, importantly, with an independent expert who was instructed on their behalf, as well as on behalf of the child. So, looking to what the Strasbourg Court has said in Litincic, that's the sort of involvement in my submission which may be sufficient. There's also the fact that the child themselves is represented in the proceedings through the guardian. Now, I accept that that's not determinative, and that the existence of the guardian and their role as representing the child isn't, as it were, a substitute for representation for the parents, but it is a relevant factor because it means that there is one further layer of independent scrutiny of the medical evidence, which is, of course, a matter of central concern to the guardian in terms of putting a case on the child's best interests. And that's relevant where, as here, the complexity or difficulty of the case is all to be found in the medical evidence. And it does appear from the note taken below that, as is not common in cases with underrepresented litigants, the judge appears to have invited Ms. Watson QC to attempt to probe with the witnesses certain matters that had been raised as concerns by the appellants. And you can see, example of that in Ms Bogle's notes in the supplementary bundle at pages 15 and 18 in relation to Dr Z, and also to some extent in relation to Dr Brierley, for example, at page 20. And that's also a further indication of the extent to which the judge maintained in his mind throughout the proceedings the importance of trying to ensure fairness to the appellants acting in person. It's also important, and this is my next point in relation to the other factors, that these proceedings are ultimately about the best interests of age. And those are relevant to whatever procedural directions the court makes, as well as to the substantive decision that it has to make at the end of the day. And in my submission, it was those interests that operated effectively as the magnetic factor for the judge in refusing the adjournment, and he was entitled to treat them as being a magnetic factor.
Mr. Anderson, I'm sorry to interrupt you, but this may lie at the heart of this appeal, at least speaking for myself, because it brings me back to what is sometimes called the cart before the horse issue in any procedural fairness case. That what a fair legal system requires is not only that the outcome should be right, but that the outcome should be reached after a fair procedure. And as my lord indicated earlier today, before the judge there was effectively only one point of view which was suggesting that the best interests of the child were different from what everyone else was saying. And that point of view was being expressed by the parents only. And so could it be said that you can't then just assume that the best interests of the child lead to a certain outcome, because that's the very issue which has to be determined at the end of the day, and that fairness required that there should be effective participation in the determination of that question by the one voice that was different from everyone else.
My lord, I think that's where it's important to look in terms of the what it is, or where it is that the complexity in the case arises, and where the disagreement arises, and where the various opportunities were for putting that disagreement. So that's why, in my submission, it is important to have regard to the fact that the matters relied upon by the appellants have been put to the clinicians. As I say, in relation to Dr. M, there's his written response. In relation to Dr. Brierley, he addresses them in his report. They're also then put again at various points in the context of the hearing. So that's a first thing. A second thing is that one has to look at it insofar as there's a disagreement about the clinical picture against the backdrop of the fact you've got the original treating clinical team who are of one view. You've got two second opinion doctors who come to the same view. You've got an independent expert who's appointed on behalf of the appellants and the child who comes to the same view. Now the judge, when he's considering whether or not to adjourn, or as the proceedings go on, whether or not it's necessary to adjourn, needn't be taking a final view on that material, but he does, having regard to the best interests of the child, have to be realistic about the fact that that evidence all points in one way. It might be different if the medical evidence were equivocal, or if there were disagreements between the various medical experts as to whether there was anything that could be done and if so, what? But in circumstances where all of that material, having had regard to points that the appellants have made about what they thought showed signs of progress, was that the treatment would be futile, and having regard also to the fact that the evidence went beyond that and was to the effect that the child was in fact deteriorating, and that's primarily contained in the evidence of Dr. Z in her third witness statement, and there's a summary in paragraphs 35 to 39 which appears at C83, the trial bundle. She expresses her shock and surprise at the state in which she saw the child on her return from a period of leave. And as Mr. Lawson submitted, deciding to adjourn is not neutral in relation to the child's best interests. It's effectively a decision to prolong treatment at least until the date of the next hearing. And the judge would be doing that in a context where there was that unanimity of clinical opinion. And in my submission, that did in this case operate effectively as a magnetic factor as to why the adjournment should be refused, particularly in circumstances where, as Mr. Lawson submitted, it wasn't certain that legal representation would be secured or the time period in which it would be secured. There were a few references, my lords, I wanted to give you just in relation to the medical evidence.
Is that the list of factors completed now, or are there more to come?
No, my lord, that's the list of, those are what in my submission are.
You didn't refer either, in going back to the list of factors in favour of the adjournment, you didn't mention the extraordinary or unusual brainstem test history. I said to Mr. Lawson that probably wasn't a factor. But do you think, on reflection, it might arguably be a factor which the judge would take into account when considering whether the parents' case adjournment was stronger?
In my submission, my lord, it is, first of all, because of the fact that it is addressed by the independent expert as well as by the treating clinicians. So it might be different if it were simply the one set of treating clinicians. It's also something that is covered in the context of the hearing. There are questions asked about that, and the judge goes to some lengths to...
What about language? Does the parents' language, the fact that they're not English in their first language, the mother speaks very little English, is that a factor to take into account?
My lord, I don't know, my lord, that there was any request for an... It didn't appear below, but I don't know that there was any request for an interpreter or suggestion that... So, I'm sorry, my lord, I simply don't...
Sorry, my lord, I'm not sure there's any evidence about the point about the mother's
either way.
English, one way or the other. There was an interpreter. He didn't appear to interpret much, and the proceedings and conversations were conducted in English.
Mr. Anderson, your answer is it wasn't a factor.
My lord, no, not on the material the court had.
One factor you've not mentioned as being a factor one way or the other in determining whether or not there should be adjournment is the factor mentioned by the judge, which was that the witnesses were all at court.
Yes, well, I mean, my lord, one can see that is a fact.
Not a factor you mentioned.
No, it depends what may be underlying the judge's. What may be underlying that is the fact that there's a number of different witnesses who've had to be convened in order for the hearing to be effective. I don't know if what the judge had in mind was that then itself imposes potential strictures in terms of future dates of availability. I simply don't know where it, or if that was with regard to the interests of the parties.
It could be said that this exchange about the factors, you've identified the factors in favour and against, only goes to illustrate the paucity of the judge's reasoning.
Well, my lords, in relation to that, I would submit that, I mean, first of all, in my submission, the court should bear in mind the circumstances that the judge is faced with, and the fact that this is an application effectively on the eve of the hearing, which is then dealt with, I think, first thing on the hearing. He obviously had the written application from the appellants. Now, it may have been better if the judge had then summarised the contents of that application and set out these are the reasons why the appellants are seeking an adjournment. But in my submission, we should, in considering the adequacy of the judge's reasons, bear in mind that the context is one in which he's explaining why he refused that application, the contents of which are set out in writing. And if we ask whether or not he's, in doing so, given an adequate explanation of why he's refused the adjournment, the primary factor in my submissions emerges from the reasons that he gave, is the, I think, used the word parlous state of the child.
Where did he say that?
I think that's at paragraph 45. Sorry, I'll just put this up. 44, my God, sorry.
So you say 44 is one of the factors he took into account. Wasn't 40? Was 45? Which paragraphs were added?
It's paragraphs 43 onwards, I think, that are the paragraphs that were originally contained in a separate email. He refers to the application. He refers to the fact that proceedings had already been ongoing, and I should note that in a sense, is the point that I think Mr. Lawson was making in relation to the fact that we're already talking about prolongation of treatment for a significant period of time in the context of the proceedings. Then paragraph 44, you have reference to the condition of the child. And then at paragraph 46, or paragraphs 45 to 46,
Okay.
you have...
I'm sorry, it's not just 43 then, it's 43
No.
onwards.
It's 43 to 46.
Okay. So it's the factors in 43, two factors. Parlous condition in 44. The fact the parents accepted the broad weight of the evidence, or broad accepted weight of the evidence, which permits a little ambiguity and reflects the consensus. They have queried the level of awareness, and they put their questions to Dr. B, and those questions were covered again with the assistance of Ms. Watson. And it's a conflict between medicine and faith, for which the father had spoken about his faith in a very articulate way.
Yes, and it's obviously not, as it were, an attempt at a transcript of a decision as it had been announced, because there's a reference there both to matters from the time and matters that have emerged in the course of the hearing. But for the purposes of asking the question whether or not the proceedings were fair, in my submission, this court is entitled to have regard to that.
Sorry. Where it seems to me the brainstem testing aspect said to be relevant is that the initial application was for a declaration of death, and that was based upon unanimous medical expert evidence, if that had gone to a hearing, no doubt exactly the sort of submissions you've been making would have been made in relation to that evidence. It turned out not to be the case, and we come back on a different basis, seeking different relief. Well, now we might find in that context, and the judge was plainly aware of that sensitivity, but might one not think that where all the medical experts' opinion had proven to be wrong before, in that context, the judge might have thought it particularly important that both for the parents, but also for public confidence in an order being made of this seriousness, that the countervailing argument was properly represented at the hearing. Because in the end, the result of this was that this second set of universal expert medical evidence wasn't challenged by a party holding an opposite view. And isn't that troubling?
My Lord, I have a couple of observations I may make in response. The first of them would be that I think one does have to look at that in context, of course, of the fact that the clinicians themselves and the applicant trust, of course, very properly took appropriate action when circumstances changed in relation to the resumption.
Yeah. I'm not just any criticism of
No,
anybody.
indeed, my Lord, but the point I'm making, though, is that that's something that is then addressed in their evidence, it's addressed in the independent evidence, and it is then picked up, and questions that are asked of the expert witnesses who gave evidence at the hearing. So that matter is both, I think, by Ms. Watson, but also by the judge himself. So that is a matter that is thoroughly explored in my submission in the context of the evidence and at the hearing. And there's a danger, of course, of it, in a sense, being used to prove too much, in the sense that there's been an explanation of how that may have occurred. There's been an indication that relevant guidelines may need to be reconsidered. But there is then, nonetheless, a consensus amongst the various professionals that that isn't the key point from the point of view of considering the futility or otherwise of the treatment, and also the prognosis going forward, as well as the evidence from Dr. Zedis that the deterioration that had been observed. So in my submission, that wouldn't in itself be a factor that would point strongly to adjourning for effectively the same point, i.e. this happened before, and why won't it happen again, or how did that happen? Those are matters that were canvassed.
Right. Well, I said I wouldn't impose a guillotine. Do you need any more time?
My Lords, no. Unless there's any particular matter you'd like me to address you on, those are my
No,
submissions.
that's very helpful. Did you want to say anything? No. Very good. Do you want to reply?
Can I just correct a reference I gave? I'll be very brief.
Yes.
I said that Dr. Brierley raised the point about ethics. It's in paragraph 41 of the judgment. In fact, I won't go through what that is based on, but it's paragraph 41 of the judgment for that particular point.
Thank you.
And not Dr. Brierley.
No. And Mr. Quintavalli, if you want to say anything in reply, I know you'll be brief.
My Lords, I'm conscious of the time, and I will give some quick references to answer points which have been made without going into any great detail. There's a difference of opinion between the Trust and the Guardian as to whether civil rights, whether Article 6.1 is engaged at all on the civil limb. The authority in the bundle is Bouloir, Luxembourg, page 469, paragraph 90. If your Lordships wish to look at that, I submit it's clear that civil rights, that Article 6.1 is engaged. I want to turn to the case of ReGB, which is one of the two domestic authorities which were dealing with, at Court of Appeal level, dealing with adjournments. And in that case, the court held that the decision not to adjourn was acceptable. If we have a look at page 485, these are just some of the factors that would have weighed in the judge's decision. We see that 2 days after, paragraph 21, 2 days after the issue resolution hearing on Wednesday the 9th of November, this plaintiff mother was telling individuals, particularly the social worker, she had lost confidence in her legal team, no longer wished to be represented by them, and was looking for replacement lawyers. So this was less than a week before the hearing. She decides herself that she's going to sack her legal team. So this wasn't the fact that legal aid had expired or some other calamity had occurred. It was a decision she took. We then see on paragraph 52 another reason that the Court of Appeal says that it's clear why the judge would have been concerned about an adjournment. He says this was the case where the judge was contemplating delay of already 1 year from the time the children were removed to foster care. So there'd already been substantial delay in that case. And importantly, if we look at paragraph 56,
we see on page 494, midway through that paragraph, paragraph 56 explaining how the judge assisted the mother during the hearing. And then he said, the judgment says, the time came when the court turned to ask the mother which witnesses she would wish to call. At that stage, the judge was able to ask the mother to spend a short time out of the courtroom with her previous barrister and solicitors to obtain assistance, and indeed to consider re-instructing them and returning them to their previous roles. So there was the presence of the legal team there. It was the team representing the father, and she wanted to have separate representation, and maybe in those circumstances that was held not to be necessary. The other case, which is mentioned in REGB, we didn't turn to it specifically, but it's mentioned, and it's the B&T case. And that's on page, I'd like to look at 3 paragraphs there, just to illustrate, again, the sort of issues that factored in the decision-making in that case. If we look at paragraph 51...
Sorry, which page?
Page 51, paragraph 4. Just a short point, but just the sort of things that were going on. 2/3 of the way down, dramatically, Mrs. T and the children then took flight, and after a period in Peru, returned to the jurisdiction, and then the proceedings could. But this was sort of background which was going on. More interestingly, on page 52, paragraph 7, the Court of Appeal explains that, so this was the legal team looking for an adjournment, explains that the mother had changed legal team 5 times during these proceedings. So this was the 5th legal team which was involved in that case, and they turned up a few weeks before the hearing saying, look, we want an adjournment. And a previous legal team, a highly experienced legal team, we're told in paragraph 6, before had assured the court previously, Mr. David Harris, QC specialist in public law proceedings, that there wasn't going to be an adjournment and that the timetable would be respected. And for some reason, that team was changed. Finally, if we look at page 53, paragraph 12, we see that in relation to the 14th of July 2000, the application for the adjournment was mounted by Ms. Irani. She was the new number 5 instructing solicitor, who laudably and bravely remained in the trial, seeking direction from the Law Society as to where her duty lay. So my submission is it's understandable why the court would have been reluctant in these circumstances to have granted adjournment. And I don't think these 2 cases are ones which assist greatly in the present case. If another option of, I just mentioned this because it was, admittedly, it wasn't presented as an option for new representation, but it's certainly one which was implicitly there. Of course, when Miss Mulholland returned from holiday, she may have been available to take the case back on. I accept the parents hadn't presented that in their adjournment application as part of their, and she was representing the parents pro bono. So the question of fundraising.
It's not consistent with her email, which said expressly that she wouldn't be available at any time in the future.
Well, if that is the case, my understanding was different, but I may have information which isn't before the court. Then, just we were referred to the case of PC and S. That was a legal aid case. An adjournment was sought because the legal aid had been revoked, and the mother wished to have it reinstated. So it may be one cases identified by Lord Justice Singh as being one where Article 6 may inform the common law, but certainly that was a case where the European Court found that there had been a violation of the Article 6.1 rights because the adjournment was not granted. And if the court is interested to see the reasoning that the judge had given in the domestic courts for not granting the adjournment. That's on that's paragraph 62 of page 355 onwards, I believe, and they're quite substantial reasons. It's quite a lengthy account as a justification as to why the adjournment was not pursued. Let me just check that reference quickly. Yes, 62 goes on over the page as well. So it's a very fulsome explanation of why the judge felt that the adjournment refusal was appropriate in that case. And just whilst we're on this case, just to pick up on a point that was made by the Guardian, and this related to the medical evidence all being one way, that seems to be tending towards an argument saying, well, look, essentially, what difference would it have made? And we have the answer there on page 365 of the PCNS case, paragraph 96, where the fact that things wouldn't have been any different if the legal team had been present. This element is not decisive as regards the fairness of proceedings, otherwise a requirement to show actual prejudice from a lack of legal representation would deprive the guarantees of Article 6 of their substance. Mention was made of the case of Riem and the delay of 6 months, the concern expressed by the Court of Appeal that was tending to be too long. The important thing to remember about the case of Riem is that was a case of a declaration of death. It wasn't a best interest case. The evidence, the brainstem testing had been performed. The child was declared by the hospital to be dead, and the parents objected to the withdrawal of ventilation. So it simply wasn't a best interest case as this one was. And in those circumstances, and given the previous case law, there were 2 or 3 cases dealing with these situations of declaration of death. The court felt that 4 months in those cases was too lengthy. I want to very, very briefly to turn to the case of Lithinchik. And the point being raised there is about the possibility of cross-examining, cross-examining witnesses, but also the right to adversarial process that the European Court of Human Rights stated existed. If we look at page 690 and 691, what we see there, and they're laying out the Croatian Administrative Procedure Act, Section 1431, the party has the right to participate in the examination of evidence, and that's where where the European Court felt the shortcoming was, or identified the violation, because the parents hadn't had the right to be involved in the examination of the evidence. But if we turn the page on subsection or section 1433, we see that there's also the right to, guaranteed under Croatian law, to participate in the examination of evidence and question the other party's witnesses and expert witnesses. So whilst it's accepted, the parents did have an opportunity to put questions to Dr. Briley. Where problems began was only once the hearing started and they weren't able to be involved in that part of the procedure. Now that wasn't, I accept, or doesn't seem to have been challenged. Maybe that part of the procedures in the Lithinchik case was not problematic, but the focus there was on the prior problems. And finally, I wanted to turn to the applicant's first witness statement, which is at D1 and D2, where the parents, on the 4th of July, so this is just after the movement had been noted, the breathing, they write this short, it's a 2-page witness statement, stating that they consider that there are signs of life in H, if you look at paragraph 7. And we firmly believe, they say, that he is not dead. Now, the significance of this is the 4th of July, 2 days after the signs of life have first been identified by the hospital. I haven't seen in the evidence at which stage the hospital, we're told they promptly revoked their own declaration of death. It's not clear when that happened, but certainly the parents weren't aware that that had been done by the 4th of July, and they felt the need to present in a very simple form, but what essentially amounts to their own medical evidence as to why they disagreed with the position that the hospital was taking.
Right.
Those, my lords, are my submissions.
Can I just check if there's more questions?
I just mentioned where I saw the reference to Mr Holland's position was in the page 108 of the application, page 108 of the bundle, the application notice evidence refers to a discussion with Mr Holland's clerk.
Yes, I accept that. That is what is said, and that may well be the case.
Thank you all very much. We're now going to rise for a few minutes so that we can decide on the next steps. we're very grateful to all concerned, and not only the advocates, for the hard work which has gone into preparing and presenting this appeal, particularly at such short notice. We're not going to give our decision today. We appreciate the urgency of the matter, and so our present intention is to give judgment on Friday. It will be listed not before 2 p.m. And in the circumstances, as I know the advocates will certainly understand, it will not be a written judgment which is handed down. It will be a judgment which is read out in court on Friday, we hope, at 2 p.m. Unless there's anything else at this stage that anyone wishes to raise, then we'll adjourn until that time.